everyone. Jess Stainbrook here with the Disabilities Association, and we're here on another episode of our podcast, Invisible in Courage. And I'm actually really excited to have two folks from a law firm here to talk about some of the things that we always have lots of questions about in the context of how to interact with any kind of disability situation. So let me introduce both Beth Davis and Sarah Demers from Cantor and Cantor, which I understand is the 2022 best law firm as according to the U.S. News and World Report. So that's a big deal, right?
Yes. Yeah, we're very happy about that.
We are.
Well, thanks so much for joining me today. And again, I know both of you are I will say experts way over my head in how to deal with different disability benefits and maybe the differences. So I think I'll start with why don't each of you give a little bio on yourself, and then we'll actually dig into some questions again that I know that you have some answers that will be really helpful for the folks that pay attention to our stuff. So Beth, why don't you start?
Sure. Hello, my name is Beth Davis. I am an attorney. I handle primarily long-term disability benefits. I also do short-term disability benefits. I am in my 18th year of practice, almost exclusively doing disability. I had 1 year as an employment lawyer and love what I'm doing now. I work at Cantor and Cantor. I've been there since 2010. And I'm happy to be here to answer any questions.
Well, thanks so much, Beth. And Sarah, how about you?
Hi, I'm Sarah. I'm originally from Minnesota. I graduated from the University of St. Thomas in Minneapolis, and I graduated in 2011, and I've been doing ERISA benefits since then. So I started with the law firm of Kate McKinnon, and then I did a short stint doing class action work, and then I came out to Cantor and Cantor because I love working around people who are very passionate about this.
Well, that's awesome. I'm actually a little excited too. You know, I coach soccer, and one of my players went to University of St. Thomas and played there. So how fun. Oh. Well, let's dig in a little bit. I'm actually going to ask, and you guys can kind of ping pong back and forth again, because you understand this way better than I do. But I know there's a lot of different benefits or I mean, how do you differentiate between the various insurances and disability things that are available, you know, Social Security, workers' comp, long-term? What are those and how do they apply to what we're talking about?
Sure.
Beth, do you want to start?
Oh, sure. So workers' compensation is primarily for workplace injuries, and it is insurance that's available to you if you are injured at work. And most states require, if not all, require that the employer is paying into a workers' compensation fund, even though it's insured. There are also, there's short-term disability. And many employers offer short-term disability that is sometimes governed by the federal law ERISA, the Employee Retirement Income Security Act of 1974. Sometimes it is governed by state law if it's what's called a salary continuation plan, meaning you go out for a short period of time, your employer continues to pay you, but it's under the rubric of salary continuation. It's really a disability plan. Some states, California, New York, Sarah, jump in if you think of any others that I'm not hitting, offer short-term disability as well to their employees. That is not in place. If the employer has a short-term disability plan, it will offset any amount you receive from the state. So meaning it'll subtract that amount. You're not going to get paid twice. And then there's Social Security disability. That's paid by the federal government. There's Social Security disability income, and then there's Social Security retirement, which sometimes folks who are reaching retirement will take retirement even if they were disabled and maybe could have gotten some disability benefits first. So that's something to keep in mind. And then there is long-term disability And if it comes from work, if you got it from a group plan at your work, it is most likely governed by ERISA. I'm going to let Sarah jump in because she really knows. She's going to tell you when it's not covered by ERISA. And then there are individual policies. So if you go out on the marketplace and you decide, I want to buy myself some long-term disability, like some of these commercials you see, Aflac, Mass Mutual, there are a lot of companies that sell what's called an individual plan. And it means you bought it yourself. You did not get it through work. That is not governed by ERISA. That's governed by state law. And if you are lucky enough to live in a state that has what's called bad faith, and the carrier denies or terminates your claim and does not do that in a good faith manner, you can get a lot more damages in court if you end up in litigation. Sarah, what'd I miss?
Well, first you wanted me to say when your plan is not covered by ERISA, and it's when you work for the government or church, then it's going to be excluded and it's going to be just an insurance contract. So it goes more into that individual disability insurance. It acts a little bit more like that when you end up in court. But I wanted to talk about, just adding on to what you're saying, the different circumstances and what the purpose of these insurances are. So work comp insurance is a little bit different than Social Security disability and short and long-term disability, because work comp will pay you for the injury. And sometimes it helps compensate you for lost income, but it's mostly for your health insurance bills and getting you back to work. They'll do more rehabilitation benefits, right, Beth?
Yep.
They do more rehabilitation benefits and stuff like that. So the purpose of work comp is if you're injured at work during the course of your duties, they want to get you back to work and compensate you for anything that you've lost because of that. Whereas short and long-term disability is not to cover you necessarily for injuries at work. It's just if you have a sickness or a disability that keeps you from working, it's insurance on your income. So to be able to replace your income, and it won't replace 100% of your income. It'll only replace a certain percentage of it. Same thing with Social Security disability. It's insurance for your income so that if you're unable to work, you can continue paying your bills and everything. Social Security disability, the standard is that you're unable to perform any substantial gainful occupation. So it's a pretty high standard to be able to get Social Security disability. They do take your age into account. So the older you get, the easier it is to get Social Security disability. There's also certain conditions where you automatically get Social Security disability, like ALS, Lou Gehrig's disease, stuff like that. And with long-term and short-term disability, yeah, they're going to pay like somewhere between 50 and 70% of your pre-disability income. And the thing about all of these benefits together, when they're integrated, is that some of them offset one another. So it's not like you're going to be able to get all of these things at once. They coordinate together depending on the terms of the policies.
Well, a lot of information there. There's a bunch of differences. Well, and in a nutshell, I mean, I think you made it pretty clear of workers' comp really is about recovery and trying to get you back on the job. And most everything else probably has to do with, and we talk a lot in our world about the difference between a disability and being disabled. In other words, not being able to perform work because of an injury or a disability or something like that. And it sounds like most everything else you talked about kind of moves into that category. You did use an acronym, which I'm going to ask you to explain a little bit more, ERISA.
Yep.
I have not heard that before, but it sounds pretty important. So maybe you can run that by me again.
Sure. It's the Employee Retirement Income Security Act of 1974. It's a federal law, and it governs health and welfare and pension. So if you get group insurance or you have a pension set up by your employer, ERISA will apply to any claims that you have that arise from those policies or plans, unless, like Sarah said, you work for the government or you work for a church. And the one thing to note with working for a church, they have the option to what's called opt-in. So a church plan can decide to be covered by ERISA if it wants to. And depending on the state you live in, the federal circuit you live in, it's beneficial to the church to opt in, because ERISA, unfortunately, very often protects the plan more than it does the participant, which is very frustrating. And also, depending on where you live, things go differently when you make a claim and it's denied. And I'm talking about under your group plan, anything that's covered by ERISA. And you have to do an appeal, and or you have to litigate if the appeal is denied. Depending on where you are in the country, the courts are more favorable to claimants in some circuits, some areas, than they are to others. And just as a quick overview, the country is divided up into federal districts and circuits. And for example, where we are in California, for the most part, the circuits and the appellate court out here are very claimant friendly. So it's a good place if you have a claim denied, because it's more likely than not going to go your way. I used to practice in North Carolina, which is part of the Fourth Circuit. Things have not changed a whole lot. It's far more plan friendly. So it is harder to make a claim, to keep a claim, to win an appeal, and to win a litigation. Not that there aren't talented attorneys to help, and we can refer folks to them anytime. But it is tougher.
Well, and it sounds like what you're saying is that there are areas that recognize the potential for helping the person with their claim as opposed to helping the company that's trying to fight it, right?
That's correct. Yes.
You did mention something too about a pension plan or something like that based off of an employer. Does that include when you kind of do your own things like a 401(b) or a 401k? Is it that kind of stuff, or is it pension like para would do for school teachers or something like that? I didn't know if there was a distinction there.
Sarah, you want to?
No, go ahead.
Take that one. Okay.
I want to talk about pension.
I don't do a lot of pension work, so I'm going to be a little careful in answering you, and say that, if there's someone out there who's listening who has a specific question, I would invite them to give us a call. We have folks who do pensions to get a very specific answer. I don't want to steer anyone in the wrong direction. But if it is a retirement plan, this is very general. If it is a retirement plan, whether it's pension or 401k, whatever it is, and it comes from your employer, yes, ERISA will apply.
Gotcha. Okay. And I do oh, sorry. Go ahead, Sarah.
Oh, I was just going to add on to what she was talking about earlier and say that ERISA is the federal law that lays down the rules for these kinds of claims and these kinds of plans, but it doesn't tell the employer what has to be in the plan. It's more like if you're an employer and you choose to offer an employee benefit plan to your employees, because you're not required to do that. If you choose to, though, then you're going to have to follow these rules. And it talks about what has to be in, or what kind of mechanisms have to be available for the claimants to make claims so that it's fair. It allows claimants to be able to appeal adverse benefit decisions. And it also gives plaintiffs a private right of action to be able to go to court in case they're denied benefits. It doesn't tell the employer what it has to have in the plan. So it doesn't say anything like you must offer long-term disability and it must have at least 60% benefit of previous income before you became disabled.
Gotcha.
And I did. Oh, I'm sorry, Jess.
Well, I in a conversation like this, because sometimes I will say, as a lay person who kind of understands a little bit of contract law, but your head tends to get really full of stuff very quickly when you're hearing all of these things. And so I do think I'll probably need to put a disclaimer on the front that says this is not legal advice or counsel. This is us having
legal advice.
This is us having a conversation that hopefully helps people understand it. And I'm going to ask some more questions about maybe the process and how people enter into this. But I do want to make it clear that that's not why we're here. But yes, you guys do this for a living, so that's okay, right?
Yep, that's great. That's great.
Sarah, you were going to add something?
No, no,
No,
I
I was
Oh, Beth,
just,
I'm
I
sorry.
was just going to jump in where Sarah was talking about litigation, and it's, if it falls under this acronym ERISA and you end up in court, people have an idea of what it looks like from watching movies or watching television. And of course, any court is not really like that, but even more so with ERISA. The claimant will not be in court. The claimant will not sit on a witness stand and talk and be questioned and be able to tell their story. The claimant's doctors will not be in court. There won't be experts. No one goes to court but lawyers in an ERISA case. And the only documents that go to court in an ERISA case are what's called the administrative record. And that is built up by the insurance company and by the claimant or the claimant's attorney, hopefully, if you're at that stage. So I just wanted to get that out there, because I think a lot of times when clients come in and we talk to them, they want their day in court. And if
They've
they're
watched way too much Law and Order, right?
yeah. And I don't, is that possible to watch too much? I love it. And the real one, the original's coming back. I'm so
I
excited.
know, right?
Yeah. But anyway, they won't be getting their day in court in that manner unless it's an individual policy. And then they would. That'd be different.
I think that's actually really good to know, again, because you're right. There is a lot of probably, I want to be cautious, but misinformation based off of media and the way that things are portrayed in a dramatic sense on TV shows and series and things like that. So that's probably a really good thing to know, that you're not going anywhere. You guys are talking on their behalf with, as an expert in front of, the other side and a judge, right?
Correct.
Yeah, awesome. Well, I do want to understand. So from the point of recognizing and having a verified disability, how does one then step into getting benefits?
Okay, so you were talking earlier about the difference between being disabled and having a disability, right?
Right.
So I think a lot of people, when they're at work, recognize that they have a condition or injury that is, there's two different kinds, right? There's the, I was hit by a car and I'm not going to go into work tomorrow and I'm going to be out for a while. I'm unable to work. So there's the sudden onset kind of stuff. And then there's the disabilities where, you have a condition that's going to be degenerative and is going to eventually take you out of work. So they're two different things, right? And I think you're talking about the second thing where it's more of a degenerative. So you're diagnosed with multiple sclerosis or, something else that's going to eventually cause you to become unable to work. You want to talk to your doctors and constantly document your symptoms, and you want to continually go to the doctor and build that record. So when you eventually go to the insurance company, you have lots of medical information to give them. You want to find a doctor who's going to be supportive of you being disabled and being unable to work. Some doctors will not fill out forms, and you want to know that ahead of time. Talk to your doctor and say, I'm not feeling great. I feel like eventually I'm not going to be able to work. Is that something that you're going to be able to help support me through? Help me fill out forms and everything for that. And you want to make sure that you're talking to the right doctors and getting the best help that you can.
Well, thank you.
Got something to add to that?
I do. I mean, that's great. And it makes me think of cases I've had where someone's been incredibly ill, Parkinson's disease, for example, and it's progressed to a point where this person cannot work. But I had a client who had a doctor who thought, in all cases, he said this to me on the phone, in all cases, it is better if the patient can work. It's better for them. And I said, well, what happens when they just simply can't anymore? And he said, I just don't think that's possible. It made no sense. This woman, that was what was in her medical record, was a doctor pushing her to go back to work. And when that goes to the insurance carrier, their response is, well, her own doctor thinks she can work. So we don't really believe that she can't. So like what Sarah was saying, it's so important when you get a diagnosis like that and you're already overwhelmed. You've got a scary diagnosis. You're wondering about your well-being going forward. You're wondering about a lot of things. But But Sarah's so right. It is really important, even at the early stages, even if I'm great today and I'm going to be able to work for several years, that doctor understands at some point, I'm going to need to help you.
Well, I do want to say at this point, I mean, it's very common in our understanding and space, if you will, of dealing with people living with invisible disabilities, that when people can't see something like an assistive device, a wheelchair, a walker, hearing aid, a mobility cane, they're not believed. Right. And it sounds like the situation you just discussed as well, Beth, is that even the doctor didn't really believe it enough to say, well, you should get back to work. And that's I think that's probably the biggest fight that we have. You know, our founders wrote a book called "But You Look Good," right? Which is a pretty common statement from an employer or a supervisor or even friends and family, right? That where somebody's not believed. And so, and I think you guys have given some great information of get a doctor, make sure the doctor supports whatever it is if the disability continues to get worse, and you do become disabled, if you will. And then also the whole idea behind how to communicate that in an effective way so that people do understand that just because you can't see it doesn't mean it's not real, right?
In our world, it's super important to do what Sarah was saying, to go in and say to your doctor, this is how I'm feeling. So many of us can, you know, we've had our own experience. You go in, you sit down, the doctor comes in, how you doing? I'm okay. How are you? And that's fine. That's a social conversation. You know, it's a social, we all do that. But don't stop at I'm okay, because the doctor, if they're not thinking, and why would they be thinking this person might make a claim one day, is just going to write doing okay today. And now you've got a medical record saying the opposite of what it is that's really happening to you. You want to go in, and after the I'm doing okay socially, then you want to say, you know, well, today or this past week, I've had a lot of pain. I've had a lot of fatigue. You want to get into that. Don't hesitate.
Yeah, I think people with chronic pain and chronic fatigue and the invisible disabilities too, like you don't like to complain because people don't like hearing you complain. So you stop complaining and you stop talking about what your symptoms are, but your doctor's office is the one place where that is really super important to tell your doctor, you know, I'm doing okay today. Yesterday, I wasn't able to walk up the stairs. The day before that, I had to miss my daughter's birthday party because I couldn't get out of bed. You know, all of that kind of stuff. You want to make sure that you're making a record of it so that when you do end up, you know, in front of the insurance company, they understand the full picture of what your health is like.
Yeah, a lot of these situations, just like you described, Sarah, is that you can feel fine one day and the next day not. I mean, you know, the chronic fatigue things or ME, or there's so many things that MS is another one where, you know, it depends on what's going on and when an episode's going to come on. And I think that's the hardest part for people to understand. I mean, we've even had stories of interactions with law enforcement where somebody pulls into a parking spot and they do have a placard and it is legal, but they walk out of their car into the mall. Right.
Oh, yeah.
And then when they come back out, there's the police officer saying, well, you're not disabled. I'm like, well, we got news for you. Yes. And so the accommodation side is really interesting of proving that so that accommodations can happen. And that's kind of what we're doing. I mean, we're creating legislation and different things that help kind of move that forward in such a way that, you know, it impacts people's lives every day in a positive fashion. So I do want to talk about this thing of a claim. In other words, just, you know, me having something and telling my boss, and when that moves to something else, what that is. And then when it moves from there where you can't get any mobilization on help, what becomes a claim that goes to a courtroom or to lawyers, and how does that work?
Sure.
I think where it usually starts is asking your workplace for reasonable accommodations. You know, you ask for, can I come in late for medical appointments? Can I leave on days when I'm not feeling well? Can I have the reasonable accommodation of being absent a few days a month, something like that? And the employer has to decide whether it's too big of a disruption at work, whether it's too big of a burden on the workplace, or whether they can accommodate that. And the rub comes when the employer is no longer able to accommodate you and is no longer able to provide the accommodations that will allow you to continue working.
Well, let me kick in real quick there. I mean, some of it actually has to do with the disability makes you disabled. In other words, that you cannot do the job anymore. And that's a piece that I don't think people always understand. You know, like if I were a blind person and yet I want to be able to drive a bus for a living, and you know, you would have to hire somebody else to do the job. You have to be able to do the job that's required. The accommodations allow for that, to the time frames to be different, or the interactive side to be different. You know, maybe you need hard of hearing, you need a special headset. Maybe you need, you know, if you were blind, you needed a special keyboard or something like that. But I do think it needs to be made clear of, you still have to be able to perform the functions needed in a job. You can't just say, I want to do this and you know, be able to then make a claim, right?
Right. You need to be, the reasonable accommodations have to be to allow you to perform the job. So every disability policy has a different definition of disability, but what they boil down to is you're unable to, on a regular, reliable basis, perform the substantial and material duties of your job. And what those are can be different depending on the insurance company and depending on your job. But, you know, for the bus driver, your essential duty is that you're able to drive the bus safely, that you're able to see, that you're able to steer and, you know, be safe doing that. For Beth and I, the essential duties of our job are that we're able to write and we're able to read a computer screen. We're able to you know, interact with people and develop legal arguments and stuff like that. That's all essential duties of our job. So it's when you're no longer able to perform those on a regular basis.
And I would dovetail from there just to add that policies, most policies, what Sarah's talking about, define your job in terms of an occupation. So they differentiate. And it's not how your job is performed for your specific employer, because maybe, you know, let's take an example of, I don't know, a lawyer. And at one firm, these lawyers are required, they're required to work 60 hours a week. It's part of what that particular firm requires. Well, you look at the occupation of law firms. Do most law firms do that? And if most law firms do that, then your job is the occupation. And in most cases, they're looking at what's called the national economy. So I'm just adding that so people keep in mind, if you've got something really unique about your job that you can't do, that may not help you. Because if they're going to say, well, could you go to employer X over there, where they don't have that unique requirement and do the job, then you're not disabled under this policy. If you could, it almost functions like an accommodation. And the other thing I wanted to add about accommodations is Sarah's 100% right. I find with a lot of people, particularly those with invisible disabilities, sorry, that's a lot of words just shoved together there. They don't ask for accommodations. They work and they push and they go and they go until they drop. And then there's no accommodation that would help them because they just can't do it anymore. And that's fine too. You know, if you reach that point and you simply, that's it, you were at work yesterday and it was the last day you could do it and now you're just done, also fine. And you can make a claim from there as well.
Interesting. Well, what are some insider tips for best supporting a claim if somebody's trying to make one?
Doctor support, doctor. And when you go to make a claim, a lot of people, you know, they reach out to HR and they say, I can't work anymore. What do I do? And HR will say, hey, here's our insurance carrier. It's MetLife. Here's the number you call to get your claim forms, to get your claim started. And then these forms come and the client looks at them and they fill, or the claimant looks at them and they fill out, there's a claimant statement and that asks for biographical information and what your diagnosis is and what your symptoms are and why you can't do your job. And people think I'm stuck to this form. So I'm in this teeny tiny little box where they give me like this much space. I'm going to write 1 or 2 sentences because it's all that fits. And then another form that they give is the attending physician statement. And that's what Sarah was talking about earlier. Will your doctor be helpful? And then the claimant gives this form to their doctor and says, could you please complete this? I need to send it in. And the doctor also thinks they're limited to this form. And I tell you, these forms are right against the line legally of what they can do
to discourage you from
Yes.
providing information.
Yes. And for the doctor, they'll send a form and it's asking about restrictions and limitations. And that's what the doctor thinks you shouldn't do and cannot do. And if it reaches a certain threshold, well, that'll take you out on disability. But they'll send in the form, the only options are claimant can do sedentary, light, medium, and the doctor has to pick one. Well, if you can't work, it should be none, but they don't give you a box for none. And then you got a doctor looking at this going, well, I got to pick one. I guess if I had to, it'd be sedentary. No, they don't have to. They're not beholden to the form.
Interesting. That's good to know.
Write a letter.
So is that a see attached? You put that in the box?
Oh yeah.
Yes.
Create
Yes.
a big old document.
Catch out everything. Yes.
Yes.
Oh, okay.
Get your doctor to a narrative. Get your doctor to say, okay, based on what you're looking for here, I'm going to write you a little letter, and I'm going to talk about, and please discourage your doctor from writing on their prescription pad, patient can't work. No. Why? Symptoms. What symptoms keep you from doing your job? Talk to your doctor about what you have to do at your job so your doctor can say, here are the symptoms that prevent this person from doing that job.
Yeah.
Go ahead, Sarah.
I was going to add on to that, just make sure you're talking about your symptoms and what they cause you not to be able to do, and not just your diagnosis. So many people will say liver cancer and then move on from there. And it's like, okay, well, liver cancer doesn't keep you from working. Throwing up on a regular basis, or being so nauseous you can't get out of bed, or whatever else happens because of that, that's what keeps you from not being able to work. So you have to talk about what is actually going on. Do you have headaches? Do you have pain? Are you tired? And how severe are those? So you have to talk about the symptoms, their severity, their frequency, and then what they're preventing you from doing.
Wow. That's very helpful. Thank you. Part of that verification, in the legislation that we create, it's about having a disability ID symbol on a government ID, like a driver's license, or having information in a database. And a lot of ours is wrapped around taking that to the next level for law enforcement. But all of the things that you're talking about help from the verification standpoint, right? In other words, how do you prove this thing that happens? I mean, our legislation, just because you have a symbol on your driver's license, you don't get any benefits from that. It's not your placard that lets you park in a special place. It really is to be used, like you're saying, with employers. So there's kind of government proof of, hey, look, I have this disability that you can't see, and I'm sorry that you can't see it, but here's how it affects me. And that goes back to kind of the claim side that you said. We have we have a couple of these things that are the invisible disability ID cards that people can wear. That's above and beyond. This is kind of a grassroots thing, but it also has some information, where you've got a photo and a QR code, an emergency contact, and things like that.
Right.
Sometimes we encourage employees to go to the HR and start to wear things like this, because it becomes a regular symbol of, hey, something's going on. I mean, our goal when somebody sees this particular symbol is to say, how can I help? You might go to a business or a restaurant, it has this sticker on it that says, National Disability ID friendly. Well, it means that they've been taught, what this means and how to do stuff with it. So sometimes in the context of before things get crazy, or you're really trying to pull completely out of work because of the disability, that ramping up of people understanding and recognizing that there's this on and off is pretty important.
I wanted to add to with your claim where Sarah was talking about list your symptoms and, really convey why they keep you from doing your job. The reason this is important and the carrier's not going to tell you this, and your employer probably doesn't know this. The burden of proof is on the claimant to prove disability. So that's what you're doing when you're listing all of these things out and you're talking about why it is this symptom keeps you from doing this duty. That's evidence. That's, and the evidence, it's your statement, the doctor, the medical records, the doctor's letter, all of this is evidence that supports your burden to prove I can't do this anymore because of my symptoms.
Which seems so unfair because you're disabled, you're unable to
Yes.
work, right? It's your burden to prove that you're
Yes.
not able to work, even though that seems like work to me. But
One more burden.
Well, and it's interesting, in our legislative language, we actually did the opposite. When it passed into a law, we created it to say, hey, if this symbol's just because the symbol's not on your license doesn't mean you don't have a disability, right? So that can't be used as something against people because they chose not to get it, because some people are fearful of discrimination, right? You go to get an apartment, somebody says, well, let me see your ID, and oh, you've got that little tag on there, sorry, well, we're not renting you this apartment. Well, that's discrimination. It's illegal, but it's a potentially could happen in any situation. So there's some folks that choose to get it, some folks that don't. But again, we've got all these different ways to support like what you're saying of the verification component is really important, no matter what part that you're stepping into. So, well, that's really cool. So what happens? We've learned that don't just fill out the minuscule lines. You can put as much information as part of the record as you want. In other words, attach other documents, do a narrative, like you said. What happens if that's denied? Well, what's a denial look like? And what do you do next to move through that?
the denial will come in writing. You'll get a letter from the insurance company and it will say, we're sorry to inform you that we're unable to approve your long-term disability application. And this is where ERISA comes in, because it tells the insurance company what they have to have in that letter. It has to say what rules they're relying on, what parts of the policy language they're relying on, what evidence they looked at, how they considered it.
Who looked at it?
Who looked at it. And so they'll give you all of the reasoning and analysis and explanation in that letter, hopefully. Yeah. And then you have a certain time period to be able to appeal it. Usually it's 180 days. Right now, because of COVID, that it's been extended, and you should, think you might be able to do it past the 180 days, but 180 days is what's safe. So 6 months you have to appeal that decision. And with your appeal, you can send in anything that you want to. You are not limited to whatever type of evidence you want to submit. You can do videos, you can do photos, you can do statements from friends and family, from your preacher. You can send in medical records, letters from your doctor, anything and everything you can think of to support your claim and refute whatever the reasoning was of the insurance company for denying it.
And one insider tip here at this stage, something that we do very often is, in addition to the medical evidence, vocational evidence. So we'll go to a vocational expert and we'll give them the medical records, and we'll give them the claimant's declaration, and we'll give them the doctor letter, and we'll say, and here's the job description if they're in what's called the own occupation period. Most policies for the first 24 months, the standard is you are disabled from your own occupation. After those 24 months, it becomes a little harder to prove. Now it's closer to Social Security, and it looks a little more like I'm disabled from any occupation out there that I'm qualified for based on education, training, or experience. Some policies will have an income qualifier, meaning that the occupation out there has to pay you a certain percentage of what you were earning before you became disabled. That burden's on the carrier to find jobs that you could do. But you are going to need a vocational expert to help talk about why you cannot do the jobs they've identified, presuming they've identified them. And then another thing that we do is called a functional capacity evaluation. And this is where a physical therapist runs you through a series of tests and exercises, and it objectively quantifies your restrictions and limitations. It shows that you have 3 hours of sitting capacity, for example. Well, that's going to keep you from doing a sedentary job, that alone. And it'll talk about, there are validity measures within it. The person's blood pressure rose while doing this test or this exercise. That's indicative of the pain that they are talking about. And an FCE can be, depending on the disease, really helpful with an invisible disability because it makes it visible. It quantifies it. And, you've got this report and it says, this person could not stand for more than 10 minutes without needing to sit down. The person couldn't make it through the 4-hour test without significant fatigue, those sorts of things. You'd want to submit that with an appeal.
Well, so when does something move from I've submitted a claim, it's been denied, I resubmitted, when does the back and forth stop and somebody seeks help from folks like you?
Oh, they should be seeking help from the claim stage, I would say. And that's not to drum up business. It's really not. It's to help you prepare a really good record. And particularly with an invisible disability, I would say that you want to get help right away, because people with experience, whether you come to us or there are some really other great attorneys out there, wherever you go, these people are going to know how to best present the evidence you do have and to take you beyond that form. And I cannot tell you how many times someone will have done a claim on their own and they will come to us and we look at it because it's been denied and we're going to do the appeal. And we look and we go, well, of course there's nothing in here. They didn't know what to do. And they didn't have any idea what to submit. And so of course the carrier denied it because there's insufficient support. What's harder still, and I'm going to turn this over to Sarah because she litigates, is when a person has done their own appeal and it's denied. And now you're going to court and there's insufficient support in the records. Sarah, you want to talk about what that's like?
Yeah, so once you submit the information to the insurance company on appeal, right? You say, I disagree with your benefit determination. I am disabled. Here's all of my evidence. Then they have to get a whole new person that did not look at the claim before, look at the appeal. So it's a new fresh eyes on it, new doctors usually that are reviewing the medical evidence and giving opinions. But sometimes those are still denied. And once a final decision has been made, you can't go back to the insurance company anymore. Now your only choice is to go to court. And you're going to be in federal court because ERISA is a federal law. And you're suing the insurance company, and the judge is really just reviewing the administrative record, like Beth said. The administrative record is everything that was generated by the insurance company in regard to your claim and everything you submitted to the insurance company. So it's all the information the insurance company has, but you don't get to put in any new information at all, which is why it's really important to get all of your information in during the appeal stage, because there's nothing new that the judge will be able to look at, because the judge is really just deciding whether or not this information that was before the insurance company is enough to support you being disabled and being entitled to benefits. So it's very difficult when people do their own appeals, don't submit enough information, and then we get into court and I say, I only have 3 office visit notes and nothing from your doctor saying what you can and can't do. I can't support a case with this. So it's good to get help early on.
I guess the one question I didn't ask is, what's the financial ramifications of opening this door? Because a lot of people may or may not have the ability to pay for what it takes to get involved with a private law firm representing. Are there funds available? How does some of this come under, I don't know, what's that status in for somebody that's working on something like that may not be a financial viable option?
So we work on a contingency basis. So unlike an attorney where you have to walk in and give them a retainer, that's not the case with us. So, and as part of that contingency, we advance the costs of things on a contingent basis as well. So if you need to go get some testing and it's going to cost a couple $1,000s, the firm will pay for that. And then what happens under the retainer is if we're successful getting benefits at, whatever stage, we're reimbursed for those costs through the benefits. And our typical retainer is 25%. And then people choose to stay with us sometimes after, if we're successful and we get them on claim, they'll choose to stay with us. The retainer stays the same. We continue to take 25% of benefits. And for some people, that's just simply not affordable. We work with a lot of really good people who, will take a look at that, and they're flexible, and the partners will say, hey, maybe this person needs to pay us only 15% or whatever the case is. But so that's a long answer to, you don't have to walk in and have $5,000 to hire us.
Obviously, there's always that, I can't afford that.
Right.
There's an immediate
Yes.
There's an immediate reaction of, I can't afford this. And so hearing that at least says, no, you come to us. There's no cost. We're gonna decide what's the best way to take this on, and
Yep.
we'll enter the system, and then we get paid on the back end based on anything that comes the direction for helping you get through this.
Yes.
Yeah. I love
That's
what we do, because we end up stepping in when people are, tired and they're sick and they really, really need help. I get to work with people every day that really need my help with stuff. And I feel like we really make a difference and we really help people.
How do you interact with the caregiver in a case where somebody might have, I don't know, maybe it's their spouse, maybe it's their child, maybe whatever it is, but they might be the person coming to say, hey, I think we need help on this thing. How does that interaction go?
We work with caregivers quite a bit.
Yes.
And especially in gathering help to support a claim and stuff like that. Sometimes when someone is disabled, they're unable to have the energy to be contacting their doctors and be talking to the lawyers and giving us all the information that we need. So the caregiver can kind of run quarterback for us and tell us what we need to know. And they can also help keep things in perspective too. Sometimes when you're going through the disability and everything, you aren't an accurate historian of exactly what's going on. And, your wife or husband can be like, you're only sleeping 4 hours at night. Don't forget to tell them that,
Right.
They can kind of help fill in some of those blanks. So definitely caregivers are lifesavers for us, very helpful.
And we step in a lot too for sick and exhausted clients. If they come to us and that they're at their limit, we'll call the doctor's office. We'll talk to the doctor about what it is you need. You just, you're going to have to give them authorization to talk to us, but beyond that, we'll do it. I've got a client right now, and I said that to her, and she burst into tears because she was so relieved to not have to do anything anymore. She's like, I tried to do this claim. It didn't work. I'm exhausted. There's no one to help me. I'm like, well, we will do it. Just forget about it. And you can even forget about what it is I need. I'll get it. I'll take care of this. You're just going to need to look at it and tell me it's accurate. That's all I'm going to have to ask of you.
That's really awesome to hear, because I know lawyers get a bad rap a lot of times.
Yeah.
No. And so this is really great to hear. What we are here to help you, and this is what it looks like moving forward. So I really appreciate that. Thanks.
Of course.
I mean, it's probably no different than any specialty, if you're trying to fill out a nonprofit, an application or anything like that. So it sounds like the earlier they get in touch with you, the better chance they have of making it through the system in such a way that they can get this through efficiently.
Yes.
Yeah. Well, what other things, this is kind of our wrap up. What other last things might you want to add to the conversation that we've had?
I would just add, I understand firsthand what it is to live with and work with an invisible disability. I have psoriatic arthritis, and on a good day, I look just fine, and nobody knows if I don't tell them. I'm still working full time, but fortunately, I'm able to work remotely. So I didn't ask, I didn't seek an accommodation. It just happened because of the pandemic. But if I didn't have that, I would need to ask for it. There's no way I could drive into work anymore. So if you need, folks who understand and get it, we're out there and we're happy to help.
Yeah, thanks, Beth. How about you, Sarah?
Yeah, I don't have anything to add. I'm sorry, man. I don't have any more information. I gave you all of my best tidbits.
Yeah, well, all of it's been very helpful. Again, sometimes it feels a little heady, but I think the great thing about this is people can come back, listen to it again, and understand. While you might be able to start navigating the process, what I've heard the most is that get somebody like you guys involved sooner than later, because if you muck it up, it's gonna whack everything for you in the future.
Yes.
So yeah, it's a lot easier for us to support the claim than it is to try and rehabilitate bad information that's already in front of the insurance company.
Yes.
Gotcha. No, that's very wise. I will say, Beth, you mentioned that the pandemic kind of allowed a lot of people to move toward home, which I actually think, while COVID has been really tough on everyone, there have been some major advantages to what we do, and people recognizing what it feels like to be someone with an invisible disability that may not be able to just get up and move out of their house whenever they want to, right? And that's what people living with invisible disabilities go through a lot. And so regular people now have experienced much of that same thing. And so the awareness and understanding has gotten a lot better. So, well, yeah, I really appreciate you guys joining me today and your expertise, the conversation. I think this is really helpful to give people some information of how do I make these steps through this process, so that a disability claim goes through, as opposed to being frustrated with it not making it through. So thank you so much for joining us, and thanks for everybody joining us again here on Invisible Encourage podcast. If you want more information, just check us out at invisibledisabilities.org, and we'll see you there.